Good morning, and may it please the Court. My name is Michael Dool, and I represent Adam Sanders. Mr. Sanders was convicted in the Plymouth Superior Court of murder in the first degree in 2003. We're asking the Court to reverse the defendant's conviction. The first and foremost argument that I make to the Court is that the jury began to deliberate in this case on June 11th of 2003.
Mr. Doolin, if the judge hadn't released juror number 7 and the verdict had been returned on Monday, wouldn't you be up here arguing that the verdict was coerced because juror number 7 wanted to get on with her business trip?
I would suggest I would not, Your Honor. I would suggest that where the coercion comes in is that juror number 7, who was the foreperson in the case, initially, when the jury was selected, said that she had a business reason, that she had to leave the Commonwealth over the weekend of the 14th and the 15th of June. The coercion, I would suggest, is that this is the juror who, during the colloquy that the trial judge has with the juror late in the afternoon of Friday the 13th, says that the jurors need a new mix, which I would suggest is a very key piece of evidence before the Court.
How do we know what that means? It doesn't really, it's totally ambiguous.
I would suggest that it's not...
Maybe she's the strongest one for conviction.
It could very well be. One of the most difficult things that we have when we're looking back at a record such as this, where none of us are in the jury room, is to try to read into what happened. But I would suggest to the Court what a reasonable inference is that there is a 10-2 deadlock on this case.
Well, that was explicit, wasn't it?
We know that.
Yeah.
There was a note that there was a 10-2 deadlock, and that the Tui Rodriguez charge was read on Friday morning of the 13th. Thereafter, there were 2 additional notes from the jury. The first one is the Court going to honor the commitments that you made to these 2 jurors, Juror 7, who is the foreperson, and Juror number 8, to leave over the weekend of the 14th and 15th. Then there is a subsequent note that comes in later in the day, and I would suggest that this is very important, and it is the 4th impasse note. And in that impasse note...
Well, the notes mention impasse, but they also seem to indicate that the jury's going on and plans to go on because they ask questions.
The next day, they said they wanted to go on.
It said that, I think the jury was looking for some sort of guidance from the Court, Your Honor. The first impasse note comes in on the second day of deliberations after about 7 hours. The judge tells the jury to continue to deliberate and to reflect on the opinions of other people who were within the jury. Then there's a second impasse note that comes in later in that day with a question about one of the witnesses.
Mr. Doolin, I want to make sure I understand your position about these 2 jurors. Should the judge not have taken note of their travel plans? They did share that information. Should the judge, was that a mistake for the judge to even receive information about their travel plans? Or are you saying the judge, in spite of being told by them in advance, once the jury reached this deadlock, should have said, well, in spite of what you told me and in spite of what I told you, you're stuck here, you got to stay?
Especially with juror number 7. In the colloquy that the Court has with juror number 7 late in the day on Friday, the juror even volunteers, maybe I should call my boss to find out whether this trip could be postponed or continued a few days. And the juror seems to be wavering about whether the foreperson wants to stay or whether the foreperson wants to go, juror number 7. At that point in time, I would suggest that there are other alternatives that were available to the judge.
What about the other juror?
Juror number 8, I would also suggest should not have been dismissed. I think that our argument on juror number 7 is far better because it is a business trip. Juror number 8 had some property that was owned by, I believe, her husband in Finland, and that they were going to go over with non-refundable tickets. I would also suggest that juror number 8 should not have been dismissed, but I think that the argument on juror number 7, in particular because of the colloquy that was conducted late in the day on the Friday, indicates that that juror had a business trip, that there was at least some possibility that it could have been put off. that the court could have continued later into the night on Friday, or perhaps have come back on Saturday morning under this type of a circumstance to continue the deliberations in the case.
What county was this in, Plymouth?
This is in Plymouth County.
In Brockton? Do you really think it's safe to keep the jurors in Brockton, in downtown Brockton, until it's dark?
I could only suggest in my own experience, Your Honor, that I know 15 years ago I tried a case next door where the jurors were allowed to deliberate on Friday night until 1 in the morning.
That was 15 years ago.
Yes.
Things were done differently then. Very differently.
It was done differently, but I also recalled that the MBTA had stopped, and we had to, at the end of the night, when the jury came back with a verdict, that we had to put them in cabs, and I had to take a cab home that evening.
Maybe the court system had more money then.
They may well have. They may well have.
Could you explain something that you say on page 9 on your gray reply brief? You say that the defendant maintains that the court's dismantling of the jury so soon after the Rodriguez charge eviscerated the protections against coercion provided in Chapter 234, Section 34. What do you mean by that?
This is what I mean, Your Honor. I think that the case law, Commonwealth versus Connor, in cases of that nature, say that to discharge a deliberating juror is a sensitive undertaking and is fraught with potential for error. We have a jury that has been deliberating for 3 days in this case, and it's apparent from the 4 different, I would suggest 4 different impasse notes, that the jurors are having a very difficult time coming to a conclusion and coming to a verdict. The 10-2 deadlock, and it didn't indicate whether it was a 10-2 for guilt or 10-2 for acquittal. But I suppose, as you can read into it, with the fact that on Monday that the jurors came back with a guilty, that it may have been 10-2 for conviction. That at this point in time, that there's certainly 2 jurors who have held in there for the defendant at that point in time, and that there are 2 jurors, one of which has said that there is a need for a new mix. And at that point in time, the jurors are dismissed. They come back on Monday, and after, I believe, 5 or 6 hours of deliberation, the defendant is convicted of first-degree murder. And that's what I mean.
No, I still don't understand. How did it eviscerate the protections against coercion?
Well,
I mean, you've given me the list of facts. I know the list of facts, but how does
this is what
protection
I would suggest that it's coercive. At that point in time, to put in 2 new jurors after the deliberations have been going on for 3 days, and to take out these 2 jurors, one of which has asked for a new mix, I would suggest in many ways is taking jurors out that may well have been for acquittal. I would also suggest that the issue of the impasse as it came on Friday afternoon would have been a call for the court to say that the jurors have been sent out once after Tui Rodriguez. Now, we have our 4th impasse note in the first one after the Tui Rodriguez instruction, and that at that point in time that the jury should not have been sent out, that this was a call for basically a second deadlock.
With respect to that, I mean, it's sort of half of one, half of the other, because it does say that. We're still at an impasse, but it also says we'd like to continue on Monday. So it's, it's
ambiguous.
This is what my argument would be to that, Your Honor. I would suggest that at that point in time that the jury has said several times that they're at an impasse. They've said it now once after Tui Rodriguez, and I would suggest after thorough deliberation and after another note asking questions about the release of the jurors. They were unsure about the release of the jurors, and I would also suggest that at that point in time that they were unsure about whether they were going to come back, stay later that night, or come back over the weekend, or be there on Monday.
But doesn't it seem that they're using impasse in a different way than we use impasse, that they're having difficulty, or they're unable to reach a verdict right now? And then they say, we'd like to continue Monday. We're at an impasse now. We can't make a decision right now. We want to continue. That seems to be what they're saying. That's a reasonable, I think that's a reasonable interpretation, that, we just can't reach a verdict now.
In anticipation of the court's question, I consulted the dictionary this morning, and there are 2 definitions of the word impasse. One is dead end, and the other one is dilemma. And I would suggest...
Well, maybe they meant dilemma. That would be right.
I would suggest that at that point in time, after so many questions and so many missives from the jury, that they meant dead end. They used the term, we are stuck at 10-2.
But if you tell me that the dictionary has 2 definitions, there's no reason to think that whoever wrote the note, presumably the 4th person, meant one definition any more than the other. And dilemma makes sense.
It's the 4th note.
Even with the word dilemma, I would suggest that because it is the fourth note, that at this point in time, and after they had said that they used the term stuck earlier in the day, Your Honor, that would mean the word deadlock or the word dead end, I would also suggest would apply. And obviously, there's no magic words. The juror, the lay people, we all sit here as professionals involved in the legal system, and the word deadlock would be a wonderful thing for me to argue, but I
Yet,
have the word
you can see they never wrote, we cannot reach a verdict. We are unable to reach a verdict, which
earlier in the day,
happens
they did say
sometimes.
stuck at 10 to 2.
Okay.
And I would suggest that that's pretty similar and very much the same thing. And I would suggest that there was no indication that there was any movement when they went back to that word impasse. I also think that the word impasse was used in some of the case law. I think it was Commonwealth versus Winbush.
Well, when they said we're stuck at 10 to 2, is that when the judge said to them to keep discussions going and listen to each other?
No, Your
No,
Honor,
that was the Tui Rodriguez.
Tui
That was the
Rodriguez
Tui.
was
Okay,
read.
so Tui Rodriguez was given when they said they were stuck.
Tui Rodriguez was given.
Okay.
That
Right.
the 10 to 2 would have been the third missive from the jury that I would suggest so that they were having problems coming to a decision. The first two were impasse on Thursday, and then Tui Rodriguez was read on Friday morning.
Why isn't the juror note, at least to the extent it says we'd like to resume on Monday, why isn't that consent to continue?
I would suggest, Your Honor, that at that point in time, that is more of a question as to what are we supposed to do. The court has already read us the Tui Rodriguez instruction. You've told us to reconsider our opinions and all the language of Tui Rodriguez. And given the fact that at that point in time, the court knew that there were two jurors who had issues, and the jurors obviously knew that other of their fellow jurors had issues about being there and leaving for vacation or for business over the weekend, that at that point in time that they're just almost asking, what are we supposed to do at this point?
Well, that's certainly one interpretation. Couldn't the judge have reasonably viewed this as a request that they be permitted to continue, which presumably could be consent to continue even though they've reached whatever they meant by impasse?
Your Honor, I would argue that under the facts of this case, where we have two jurors who have those issues, and that in the prior note they had brought up those issues about travel, that for them to continue on Monday they were obviously asking as well in the prior note as to what are we supposed to do with these other two jurors, our fellow jurors, including the foreperson, who are supposed to leave on these travel plans. And all of the notes that were given from the jury, they all contain language in addition to we are at an impasse, and that they do seem to be, over the course of those 2 days, Thursday and Friday, asking for further instructions as to what their role was and how far they were supposed to go. Another issue that I would ask the court to take a look at respectfully is the closing argument of the prosecutor. There were 6 instances, I would suggest, where the prosecutor in the closing argument impermissibly vouched for the credibility of witnesses. 4 of those go to the Commonwealth's, what I would assert is the main witness, Rotunda Harper. Ms. Harper was one of 2
Before you get too deeply
ma'am.
into that, I'd like to ask you just a question about another subject. Did the defense counsel request a continuance to get a summons for the Sergeant Harrington for his testimony about his interview of the witness Brantley?
He did not.
So,
He
okay.
did not. There was the Brantley issue was when Mr. Brantley was on the stand under cross-examination, he was asked about his conversations that he had with Sergeant Harrington. I believe that there was a sidebar where trial counsel then requested any documents related to that, and there was no request for a continuance at that point in time. As to the vouching, there are 6 instances, in 4 of which go to what I would assert is one of the Commonwealth's main witnesses, Rotunda Harper. Rotunda Harper was the same witness that the jury had asked for a transcript of her prior testimony in the case. And obviously the jury was having a very difficult time in assessing her credibility. Harper, at one point in time, was said by the prosecutor in the closing that her testimony has the ring of truth. We had to pull the truth out of her. A certain period of her testimony were 5 seconds of her proof of honesty. There were also 2 other instances of vouching, one as to a state police officer and one as to another witness, Mr. Coakley. And I would suggest that in the totality of those things, that it is impermissible for a prosecutor under Chavis to vouch for the credibility of witnesses. I would also suggest that in the prosecutor's closing that there were 3 misstatements of fact, 2 of which were objections that were sustained by the judge at the time, leading to a curative instruction. And based upon the totality of all of the factors of the closing arguments of the prosecutor, I would suggest that there was certainly error. As to the last factor I'd ask to argue to the court today, there was a witness whose name was Baskins, Leonard Baskins. Mr. Baskins was an individual who had information that was given from his attorney, was given to the prosecutors down in Plymouth County, that another individual had committed the murder. This individual had a name or a nickname of Kozel.
Mr. Doolin,
Yes, Your Honor.
was the Baskins information that he had paid Kozel or Kuzel to do it? Or?
Well, I think that's one reading of it.
It's in the affidavit of the lawyer, of counsel,
Yes.
trial counsel, that's
Mr.
the information
Holmes'
conveyed to him.
Holmes' affidavit?
I think it's in Mr. Weinstein's affidavit.
Yes, Mr.
Weinstein was the attorney for Mr. Sanders. Baskin's attorney was Stephen Rones. Baskins had a federal case that was going on. Rones was representing him at the time. Mr. Rones contacted the prosecutors down in Plymouth County saying that he had a client whose name he initially withheld, but it ultimately became Mr. Baskins, who had information that another individual named Kozel that he had seen Kozel commit the homicide of Mr. Wise, the victim in this case, and that he had done it at the behest of 2 individuals named the Hicks brothers, who were evidently involved in the drug trade down there. Initially in the affidavit, that there was $10,000 that was allegedly given to Kozel by Baskins at the behest of the Hicks brothers after the incident had happened. But I would suggest that the affidavit, it was a very, very narrow assertion in there, and it was never really flushed out in any form as to whether or not, for instance, Baskins knew that the $10,000 payment was in return for killing Mr. Wise. In a factual scenario, Baskins was in custody here in Massachusetts, and then in May of 2003, he was sent to the state of Texas because he was going to go serve a federal sentence. There was an inquiry that was conducted prior to trial on May 22nd, and in that inquiry, I would suggest that there was error in that a full Lumen Martin type hearing was not conducted. Mr. Baskins was never inquired. Obviously, he was in the state of Texas, but he was never transported to Boston.
His lawyer was there at the
His
hearing.
lawyer was over the phone, Your Honor. His lawyer participated in the hearing, Stephen Rones. There was a phone call with Rones, the Commonwealth, the defense, and the motion judge, who was Judge Grabeau. And in that, interestingly, I would suggest Mr. Rones doesn't say that the client is going to take the Fifth Amendment. He says that the client is not going to come back here without immunity. And there was also, I would suggest, with Mr. Baskins' issues about him trying to get some sort of a deal, so to speak, with the federal authorities because of what he hoped would be consideration for giving truthful testimony on this case. There is that reference to the $10,000, which I'm sure the Commonwealth will argue is some obvious Fifth Amendment issue. But I'm going to suggest that the standard under Lumen Martin and the standard under taking the Fifth Amendment is that there has to be more of an inquiry than was done in this case. Rones did not claim the Fifth Amendment for Mr. Baskins.
But he was seeking immunity.
Obviously, with the fact that somebody is seeking immunity, that there are issues. But I would suggest, Your Honor, that the immunity in this case was more of this fellow Baskins trying to get some sort of a deal with the federal authorities in return for what he would consider to be truthful testimony, than it was strict immunity for whatever actions he took in connection with the case. And the actions that he took in connection with the case were never really flushed out in any sort of a way that it would lead a judge to say that this individual definitely had the Fifth Amendment.
You know, I thought I had seen it in one of Mr. Weinstein's affidavits, the fact that this fellow also acknowledged that he had paid the $10,000 for the murder. Do you remember whether it was in one of his affidavits?
I think it was in one of Mr. Weinstein's affidavits.
All right. Okay.
I know that Mr.
can't really
Rones
find
also
it.
wrote an affidavit, but I think Mr. Rones' affidavit wasn't as specific
Okay.
as to that point.
Thank you, Mr. Dooley.
Thank you very much, Your Honor. Thank you, the court.
Thank you.
Ms. Semmel.
Good morning. Catherine Semmel, appearing for the Commonwealth. I'd like to address just a couple of issues, two of them being the two juror issues or jury issues that arose. I think as to the excusing of juror number 7, a lot of what the court did has to be viewed in the context of her commitment to the two jurors on the first day of trial, that she would in fact excuse them if necessary, if in fact the trial went longer than expected and ran into their travel plans. There was no objection when she discussed this with the jurors. There was no discussion when these jurors were seated. The judge did take the precaution of seating an additional juror in an abundance of caution, but clearly...
But obviously, everybody was expecting that this was not going to be a non-issue.
Yes,
I mean,
the
I
trial was
don't-
expected to conclude on Wednesday, which it in fact did, and it was expected that by Friday a verdict would be reached. But once the judge had made that commitment to these jurors, she was in a little bit of a different position because, as she said when the issue arose on Friday, I'm concerned about there being a coercive effect. She was concerned that if she pushed the jurors too hard, that there would in fact be coercion in making them stay, that there might be a rush to judgment, that they might be disgruntled, that they couldn't pursue their plans. So I think she towed a careful line when she said to the two jurors, you know, it would be best if you could stay, it would be preferable if you could stay, but if you feel that you need to complete these pre-travel plans, I will stand by my prior commitment.
Don't you think, though, with respect to, was the foreperson 7?
7, yes.
She did express some ambivalence on her own, that maybe she should call her boss. She wasn't going till Sunday. I mean, it did seem to me that there were other alternatives other than that afternoon excusing her.
I think she did express some ambivalence, and when she did, the judge, I think, reiterated it would be preferable for you to stay. But in the end, the juror said, I think I should go. It's an important trip. She did say, perhaps I could call my boss. She hadn't called her boss. She hadn't tried to make these plans. And in the end, she said, it's an important trip. I think that I should go.
I mean, I guess that this is the issue. I mean, it's good cause, a perhaps movable commitment that a trial judge has made.
I think that in this instance, it was good cause. I mean, it was stated right up front that this was a reason. This wasn't a situation where it was a manufactured reason. It was clear from day one. She said up front, I have this trip. Whether or not she could have moved it, I don't think the judge could pressure her any more than the judge did. The judge repeated several times.
And isn't the problem that if the juror had called the boss and the boss had said, oh, all right, or something like that, or we can postpone it, it seems to me if there were a conviction, the defendant would be up here arguing
Well,
that
but
this
we're not
juror had
there.
been convicted.
Absolutely,
But I mean, so
sure.
the judge is between a rock and a hard place.
She is.
Once the trial goes longer than the date anticipated, she had to jump one way or the other. Either one is going to create an appellate issue if there's a conviction.
And she's got to have some discretion on the subject.
She
right?
does have discretion to determine whether it was good cause, absolutely. And she was in the best position. The whole idea, I know the juror also threw in the issue of a better mix, which, as the justice pointed out, was an ambiguous comment. It could have meant a great many things. And the judge was in the best position to determine whether that factored in. And certainly we've had cases where there have been issues in the jury room, and that's been an issue on appeal. The judge clearly determined in this case that was not the case, that there wasn't a manufactured reason. And in fact, her very ambivalence about going, I think, suggests that she wasn't trying to get out of anything. She felt badly about leaving, but I think in the end, she felt that she needed to go. And I do think we would absolutely be here on a coercive argument if that juror had remained and there had been a conviction in the end, regardless of how exactly it had come about, because she was promised it, and the judge would essentially be going back on her word. So the judge was in a difficult position, and I think she did exactly the right thing. I think she made the appropriate balance between urging them to stay if they can, but saying that she would stand by her commitment to dismiss them if they didn't. And then she made an appropriate instruction to the jury on Monday, explaining that the jurors were, in fact,
Well, isn't
dismissed.
it maybe a situation where the judge could have gone either way, and neither one would have been an abuse of discretion? It's a discretionary call, and either action by the judge, advising the juror to call, and maybe the boss would have said okay and keeping her, okay if the judge decided in her discretion to do that, or excusing or keeping the judge's commitment.
In either case, the judge was in a tough position. And in either case, there would have been a complaint from the defendant how it ended up. And I think in this case, an appropriate balance was struck by the judge. The second issue concerns the jury impasse. And you know, the statement at issue is the same communication that actually led to these jurors being dismissed, which is important to some extent. But basically, it was the jurors say, is it possible for us to resume on Monday? We're still at an impasse. And there was no argument at that time from the defense that another Tui Rodriguez situation had been created. There was no argument at that time that there had been a second return without a verdict. And I would note also that in the two prior times that the jurors had used the term impasse coupled with some indication of continuing deliberations, and no Tui Rodriguez was given, it again was not requested by the defendant. I think everybody seemed on board. There were short discussions about certainly the first two. I'm not sure about the last one. But I think there was actually that the jury was indicating a desire to continue. The only time when they didn't indicate a desire to continue, when they said, we're stuck at 10-2, please advise, the judge gave a Tui Rodriguez charge. And again, everyone agreed that it should be given there. But in these circumstances, I think the case law is clear, and the judge, again, has a lot of discretion in this situation. When you get an ambiguous communication with the jury, from the jury, which indicates that they're willing to continue, then the judge certainly can consider that not an intractable deadlock.
So there was no argument by the defense counsel at this point. That's post-TUI, end of subject, unless they affirmatively consent.
No, there was no argument at all. Correct. Excuse me. Yes. And in fact, you know, I have to say, in retrospect, given that the two jurors were being dismissed, and this all came about as a result of the same communication, it really wouldn't make a lot of sense to give another charge at that point, because the jury was about to be reconstituted and begun anew on Monday. But in any event, the judge certainly had discretion, and there was no argument that suggested any differently. And clearly, the jurors were using the term impasse in a loose sense. In fact, the one communication that triggered the Tui Rodriguez is the only one that didn't include the term. But in any event, it was clear, I think, that they wanted to continue deliberations. The other issue I'd like to discuss a bit is just the issue of the Leonard Baskins, the witness.
Could I ask you
Texas
first,
Yes.
did Harper, the witness Harper, in fact, adopt her grand jury testimony?
It's not really fleshed out in the briefs at all. What is that all about?
I think you know, it came up after the fact when the defendant asked. Perhaps it's when the jury came back. It wasn't discussed at the time. I'm sorry.
What was the trial setting? What happened? Harper's testifying.
Harper testified. There were some allusions to her grand jury testimony. There were some differences in her testimony. I don't recall the specifics of them. And after the fact, the defense counsel argued to the judge that the judge should, in fact, instruct that any statements that she adopted could be considered for the substantive effect. The judge was a bit resistant to that, but the defense counsel
I mean, this was in
convinced the
response
judge.
to the juror note.
Yes. Yes, Your Honor.
Was there
And
any argument that if you're going to give one witness's transcript, you should give them all?
if you should give one,
In other words, the judge gave the transcript of the testimony to the jury? is that
oh,
right?
yes, yes, Your
Was
Honor.
there any argument by the defense or the Commonwealth that if you're going to give one witness's actual transcript of testimony, you shouldn't do that unless you give everybody's testimony?
I don't believe so, Your Honor, and I think that the jury requested specifically the last 5 minutes of the testimony. I think they agreed that they should give it all, but I don't remember any discussion about other witnesses at all.
This portion of testimony that was requested, was this redirect examination, cross-examination? What was this?
I believe there was examination both by the defense and by the Commonwealth, and I don't recall the exact context in which it came up. And it
Wait, I
wasn't
thought it was
discussed
the
to any
grand
great
jury
extent.
testimony that was given.
Yes, but I think the judge's question was whether this came up in cross or direct examination of the witness at trial. And I believe it came up in both cases. I think both the Commonwealth and the defendant questioned her about.
But what was given to the jury was the witness's trial testimony.
Yes.
Correct? Not the witness's grand jury testimony.
Correct.
Trial testimony in which she was either, I guess, impeached in some fashion with inconsistent grand jury testimony, or a grand jury testimony, I should say.
Yes.
So the question was whether she had adopted that grand jury testimony or whether it should be used as just an inconsistent statement.
Yes, Your Honor.
Right. And the jury was properly instructed on that, or
And
no?
the jury was properly instructed.
And that instruction was at the request of defense counsel?
Yes. Yes, defense counsel argued that it could be considered substantively if she adopted it, and that then it was then a jury question whether she had. With regard to Leonard Baskins,
I'm sorry
yes,
to keep interrupting you,
oh,
but I
that's all right.
had another question. I don't think you really, or I wonder if you really dealt with the individual claims that the defendant had regarding ineffective assistance. They're on pages 46 to 47 of his brief. I think you indicate that they're waived.
well, I think what I indicated, Your Honor, is that there is no record developed as to these claims, that there was, in fact, a motion for new trial, but that these issues were not raised at the motion for new trial, so that no record was developed. And, in fact, there's no way to assess these claims. I don't know who the two witnesses are that they were discussing. There is no factual basis for these claims. There's nothing that's in the record. And that was my response, that it's impossible to assess because there was no record development.
Thank you.
You're welcome. So Leonard Baskins, the courts have discretion as to whether or not to produce an out-of-state witness. And in this case, the judge exercised his discretion not to produce the witness based on the assertion of privilege by Mr. Baskins' attorney, which was obtained through phone conference, and through considering the factual basis for that privilege, which was not directly produced by Mr. Rones during this phone conference, but was produced by documentation that was already part of the record, in which, in fact, this documentation, in fact, the letter that the justice was referring to, and I believe there's a letter from the ADA, who originally was working on the case as well, these letters set out the factual basis for the privilege, and they were, in fact, letters that were part of the record because the defendant had submitted them in connection with a request for the court to compel the immunization of Mr. Baskins earlier in the case. I don't think there was any factual dispute as to the proffer of the facts here. They were, in fact, originally proffered by the defendant himself, arguing that you should immunize this defendant because he has Fifth Amendment rights. So when it came up at the time of trial, or prior to trial, and there was a question about whether to produce them, I think it was entirely reasonable for the court, given an assertion of privilege and given a clear factual basis for applying it, not to produce this witness. And this is not a Martin situation where the question was, is it okay for the court to have a hearing? The question is, did the court have to have a hearing? Did they have to bring the inmate from Texas to assert this virtually non-disputed claim? And that I don't think there's any Massachusetts authority right on point. We cited a few out-of-jurisdiction cases which have clearly held you can rely on an attorney's representation as to an assertion of privilege. You don't have to have a hearing. Are there any further questions from the panel as to any of the issues that were raised?
Can I ask you just this phone conversation in which Mr. Hones participated as counsel to Mr. Baskin?
Yes, Your Honor.
I'm trying to see what exactly he said. The judge says, I understand that he will not testify unless he's given immunity. Is that, in essence, did I summarize your part correctly, Mr. Hones? Yes. Almost, yes. That's his position. he called me. So did I state it correctly? He would still like immunity to testify. Yes, he's not going to testify unless he gets immunity. You think that's an adequate assertion of the privilege under the circumstances?
I think, Your Honor, yes, that is adequate.
Thank you.
Thank you very much.